So thank you everyone for joining us today. I am Ioana, one of the co-conveners of the BSA Theory Group, and I will be chairing the event today. We are all very excited to be joined today by Jana Bacevic, who will be delivering a presentation between approximately 35 to 45 minutes. Jana's presentation will be followed by Naomi Waltham-Smith's response for approximately 15 minutes. Now moving on to introductions. Jana is Associate Professor in the Department of Sociology at Durham University and Associate Editor at The Philosopher, which is the UK's longest-running public philosophy journal. An interdisciplinary social and political theorist, Jana has written and published extensively on a wide range of socio-political matters and will be soon starting a Leverhulme Trust-funded project to develop an ethics for the post-Anthropocene. And I would like to highlight here two of Jana's publications in particular, given the theme of today's event. The article titled "No Such Thing as Free Speech, Performativity, Free Speech and Academic Freedom in the UK" was published in the Law and Critique Journal in 2023. And just a few days ago, Jana's latest article was published in the British Journal of Sociology, titled "What is Social Science if not Critical?" I encourage everyone to access these articles after the event. And our discussant, Naomi Waltham-Smith, is a professor at the University of Oxford and Douglas Algar Tutorial Fellow at Merton College. She is an interdisciplinary scholar working at the intersection of recent continental philosophy with music and sound studies. Naomi is currently working on a monograph that excavates a hidden concept of listening in the history of political philosophy, in the hope of illuminating the challenges facing our democracies today. Finally, I would like to note that the popularity of this event and the high number of registered attendees are testaments to the excellent scholarship that Jana has produced over the years and the importance of holding collective discussions around the meaning, practice, and politics and the implications of academic freedom and free speech. And on that note, Jana, let me know when you are ready to start.
Thank you so much, Ioana, for the invitation to speak at the BSA Theory Group event. Thank you to Naomi for agreeing to be the discussant. I highly value Naomi's work, and I'm certain that the comments will be more than constructive and useful for us as we engage in this discussion of academic freedom and the politics of free speech. And not least, thank you to all of you who have taken the time to join us today, because as Ioana has said, it does seem like this is a topic that inspires, let's put it that way, quite a lot of interest. I'm just going to start sharing my screen because I do in fact have a PowerPoint. So why is it that we're discussing academic freedom and the politics of free speech? One obvious reason is, or as a backdrop, is UK government's Higher Education Freedom of Speech Act, which was introduced or enacted in May 2023. But beyond that, or even before that, over the past 5 years, we have witnessed an array of what I would refer to as high-profile cases of no platforming, notably in the UK. The philosopher Kathleen Stock has argued that her contract had not been, or that her contract had been terminated at Sussex University because of her views on transgender issues. A couple of years before that, Jordan Peterson, who I believe needs no introduction, had his invitation to the Cambridge School of Divinities, or to become a visiting fellow at the Cambridge University School of Divinity, temporarily rescinded also because of reactions of student unions and academics to his publicly announced views on trans issues or transgender identity. But more recently, and after the UK Higher Education Freedom of Speech Act had been promulgated, we have seen increasing cases of silencing, in particular since the conflict in Gaza, shall I say, restarted. And that has to do in part with the ways in which academics have been penalized for speaking out about Palestine, but also I think to some degree has to do with self-silencing in the sense in which academics have started exercising, I would say, self-censorship when it comes to speaking about these issues. To give you a sense of what I'm talking about, a series of events, I think of the rare institutions in the UK that actually have had the courage to platform or talk openly about what is going on in Gaza, or what has been going on in Gaza since October 2023, have titled their series Accept Palestine, I think in part as a reflection of the fact that there is now freedom of speech or freedom of expression for all kinds of issues, with the exception of Palestine. In relation to this, at around the same time, there was a relatively, again, high-profile case in which, at that point, the Minister of State for Science and Technology, Michelle Donelan, was eventually forced to pay a fine or compensation to Professor Kate Tsang, who is an academic at Heriot-Watt University. At that point was also the chair of UKRI, so UK's main research organization or research association. So Tsang was at that point the chair of UKRI's EDI committee, I think steering group, advisory committee. Sorry about that, because Donelan falsely accused Tsang of tweeting something or posting something on X or Twitter that Donelan referred to as support for terrorist acts or support for Hamas. In other words, what the whole the interaction demonstrated was, in fact, that there are different understandings about what constitutes freedom of speech and how this freedom can or cannot be exercised in relation to different platforms and different topics. Now, the freedom of expression in the UK is in and of itself protected by the human right, or defined in the Human Rights Act, as the freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. However, the Act does recognize that certain platforms can, under certain conditions, exercise constraints on freedom of speech or freedom of expression or depending on what they are, depending on certain kinds of things such as interests of national security, territorial integrity, or public safety, and so on and so forth. Why are we talking about academic freedom, though? That is the more interesting question for me, at least. First of all, most of these conflicts, or the conflicts, controversies that I have just described, refer to or pertain to speech at universities. So in particular, or in the case of particular platforms that universities represent. Or alternatively, when it comes to speech by academics on social media, they actually happen on the boundaries of universities. And as Ioana has kindly already said, earlier, de facto last year, but formally earlier this year, I've published an article which actually focuses on the analysis or critical analysis of the UK's most recent legislation pertaining to the intersection between freedom of speech and academic freedom in university contexts. But before that, this is a shorter piece that preceded it. Before that, I've had a longer lasting interest in the question of what are actually boundaries of institutions. So what is this controversy around, for instance, whether protections for academic freedom and or freedom of speech should extend to what academics or the kinds of statements or claims that academics make on social media. For those of you with perhaps longer institutional memories or an interest in the history of these discussions, one of the cases that I discussed in the 2018 paper is Stephen Saleta, a professor at University of Illinois, or a professor whose offer of tenure at University of Illinois was rescinded in 2014 because Saleta, guess what, tweeted something critical about Israel's, at that point, campaign in Gaza. So these discussions actually have a longer history. And what I'm particularly interested in, and that is moving towards some of the stuff that I'm focusing on now, is the question of how academic freedom features in these discussions. And my interest in this stems from the fact that academic freedom in and of itself is an ambiguous concept. What do I mean by an ambiguous concept? So when we, and in this particular context, I'm using we as a broad definer for academics or people who are somehow interested in questions of academic freedom specifically, which is mostly people who stay or who kind of tend to stand to benefit one way or another from academic freedom. So people to whom academic freedom and its provisions may extend. We are not entirely sure how we feel about it. On the one hand, we tend to think that academic freedom is a good thing, but then on the other hand, we're also increasingly aware that academic freedom can be used, or maybe, let's put it openly, abused. So in that sense, academic freedom becomes a sort of concept that we have a form of ambivalent attachment to, or an ambivalent attachment to, at least as an epistemic or analytical term. Now, what I'm arguing, and one of the things I am working on when it comes to the upcoming Leverhulme project, is that this, I think, is the case with all kinds of freedom. So increasingly, we're becoming aware of the fact that situations, or the situations that contemporary political and social worlds present us with, are situations in which we need to justify why is it that freedoms that, at least under the standard Kantian narrative, should apply to everyone equally. Our own freedoms should be the guarantee of other people's freedoms, or our own freedoms should be the guarantee of the degree to which we're likely to extend those freedoms to other people as well, and vice versa. So why has this, so to speak, expectation broken down? Why is it that increasingly we actually are not so sure that the freedoms we wish to enjoy, we wish to extend to other people? And alternatively, why is it that we're in a position in which we become increasingly aware of the fact that some people's freedoms might, in fact, limit our own, and how we relate to this? Now, when it comes to the question of the intersection between between academic freedom and freedom of speech, the UK's Higher Education Freedom of Speech Act morphs them explicitly. So the opening statement of the Act says that it is there to make provision in relation to freedom of speech and academic freedom in higher education institutions and for connected purposes. Why? So why would a government want to morph or blend academic freedom and freedom of speech? That is the opening question with which we will start our inquiry today. So why legislate at all? Secondly, when we introduce that kind of legislation, who is actually empowered or enabled by such acts? And then, last but not least, what does free speech do in this particular context? And in this case, we're on the terrain or on the ground of performativity of speech acts, of which I will say a bit more shortly. Let's go back to the first question. Why legislate? Why protect the intersection of academic freedom and freedom of speech in the first place? Academic freedom in the UK is officially protected initially, or first appeared in legislation in 1988 in the Education Reform Act. Again, those of you with longer institutional or legislative memory may recognize this as one of the first acts that were promulgated by Margaret Thatcher, as at that point the State Secretary for Education first and then Prime Minister. And the era defines academic freedom as the freedom of staff to question and test received wisdom and to put forward new ideas and controversial or unpopular opinions without placing themselves in jeopardy or losing their jobs or the privileges they may have. 1988 is a year that marks another really important international date for academic freedom, and that is the signing of something called the Magna Carta Universitatum. Now, this is a major document signed by rectors of over 200 universities worldwide. Quite a few UK universities were among signatories to the original Magna Carta Universitatum, and that is a document that, at the point at which it was introduced, which was a year before 1989, so a year before the Berlin Wall fell, a year before the reunification of the East and the West of Europe began, and together with it, a lot of other processes, actually clarified the need for universities, or the need for university autonomy to be protected, recognizing that the reconfiguration of political space, not only within Europe, but obviously globally, with the, at that point, incipient fall of the Soviet Union, posed new challenges to the relationship between universities and political regimes. And this is what it said. It recognized the university as an autonomous institution. It placed it at the heart of societies, which it said were differently organized because of geography and historical heritage, and it stipulated what it should do. Some years later, UNESCO's recommendation concerning the rights of higher education teaching personnel further specified that it is actually people who teach at universities, so academics, who should be protected from untoward political pressures. So what kind of freedom is in fact promulgated by this new kind of law? In order to understand what is specific about the intersection of freedom of speech and academic freedom, I think it's useful to have recourse to the distinction that Isaiah Berlin introduces in a rather famous essay called Two Concepts of Liberty. Berlin distinguishes between two kinds of freedom. One is negative freedom, which is mostly defined as freedom from, so freedom from intimidation, freedom from persecution, freedom from discrimination, the kind of things that these definitions of academic freedom mentioned previously actually protect. Positive freedom, on the other hand, is something that we today may otherwise or more easily identify as entitlement. So that's the freedom to. It's the freedom to do something or entitlement to something, including, for instance, entitlement to a platform. Those of you with an interest in human rights or human rights terminology might also recognize this analogy or might recognize this terminology by analogy with negative and positive rights. Now, Berlin, as a theorist of liberalism, was of the opinion that liberal states should constrain themselves to legislating on negative freedoms. So should remain constrained to protecting people from undue interference or persecution based on obviously a lot of things, but mostly their identities or their political views, but that they should not, in fact, legislate on positive freedoms. In other words, that we should not tell people what to do. We should just make sure that they're free to do what they want to do under obviously certain provisions and with certain constraints. And I'll be getting back to those and what these mean and how they're being reframed at the present moment towards the end of my talk. Now, when it comes to this, academic freedom is mostly a negative freedom. It's mostly freedom from. It's freedom from intimidation, or as we could see, undue dismissal due to expressed views. Freedom of speech, however, is mostly defined or interpreted in the context of the new legislation as a freedom to. So freedom to express views. It happens when these two clash. I am not going to entertain you or indulge in lengthy reading of the Higher Education Freedom of Speech Act. As all public acts, it is publicly accessible, so you can do that. But what I want to give you a sense of looking at these different snippets of the law is that it in effect stipulates quite a lot of obligations on the part of universities and institutions, including specifying who it applies to, including constituent parts of the university, such as student unions. And furthermore, stipulates that the universities, or the universities, must promote the importance of freedom of speech, including academic freedom. Now, by way of an analogy, I want to ask you to think about what an analogous formulation in terms of obligation to promote would mean if, for instance, we took equality instead of freedom of speech, right? So obviously universities, including universities in the UK, are obliged to not discriminate or to act in accordance with the Equalities Act in terms of not discriminating towards people, but the obligation to promote equality would mean something rather different and would definitely put us on the grounds of what Berlin would describe as positive liberties. So freedom of speech in this case is very clearly a positive liberty, but it is at the same time an obligation for universities. To understand what this kind of obligation does, we need to delve into what I tend to call the social life of concepts. So what is actually happening with the intersection between academic freedom and freedom of speech? One element of this is to basically ask questions about ontology. So to ask, what is this thing? What is academic freedom when it becomes defined in part as entitlement to a platform? Who has the right to define what freedom of speech and or academic freedom mean in the context of universities? And obviously, how is the concept used or made to work? But we also need to think about performativity, which is, what does this concept do? So how do concepts act? When we talk about how concepts act, the most frequently relied on theoretical framework is, in its origins, usually associated with John Langshaw Austin and his rather famous book or a series of public lectures called How to Do Things with Words. Austin stipulated something known as the concept of speech acts, and I will be saying a bit more about that shortly, which is the idea that words actually are not only words, that they also do things. And then following that, Catherine McKinnon, in a poignantly named book called Only Words, engaged with the question of what do words do when they take the form of different kinds of representation. And Judith Butler in Excitable Speech, a book that came out initially in 1997 and has recently had a second edition, in part as a response, with a new preface, as a response to the different contestations around platforms and free speech. So Butler engages with the question of how is it that words actually become performative. So briefly, and I apologize to those to whom this is bread and butter things. So Austin's concept of speech acts builds on the distinction between illocutionary and perlocutionary speech acts. So Austin starts from the idea that saying things is always more than just saying things, and that in effect, words are performative when they also do things. Austin uses several examples. So for instance, an example of an illocutionary speech act is an act that achieves something just by being said, is to say, I apologize. If I say I apologize, I have de facto apologized. Now, we can obviously dispute whether I was sincere when I apologized, whether the apology was well received, and so on and so forth. But it's very difficult to dispute the assertion that by saying I apologize, I have offered an apology. However, perlocutionary speech acts are speech acts that require certain kinds of conditions to become actually effective, so to do things. One of the frequently used examples, including those, the class used by Austin, are institutional speech acts that actually do things only if they are uttered in a particular context. So for instance, to say, I take thee to be my lawfully wedded wife, in order for that to become an act of entering a marriage union, that act needs to be performed under particular conditions, usually by an official and under circumstances that are usually recognized as a form of marriage ceremony, right? Other than that, it can be uttered outside of those conditions or circumstances, but it will not act, it will not do things in that way. So that's an example of a perlocutionary speech act. Theory of performativity when it comes to speech acts has had several tweaks over the years. And I think some of the good and recent relevant examples include Sarah Ahmed's notion of non-performativity. Ahmed wrote quite extensively about, for instance, the non-performativity of anti-racist initiatives in universities. Non-performativity in this particular case means that speech acts can actually, despite being supposedly meant to do something, in this particular case, to fight against racism, they can in fact not do anything. So the mere fact of saying something, for instance, making declarations or making statements, is actually what prevents anti-racist work from taking place. Don McKenzie, relatedly and not long after that, has developed the notion of counter-performativity in the case of algorithms and financial trading, and I will not have time to get into that, which basically is about certain kinds of statements, algorithms taken to be statements or claims in a very broad sense in this particular case, doing exactly the opposite of what they're meant to do, but not intentionally, like Ahmed argues is the case with anti-racism, but unintentionally. Now, Catherine McKinnon developed the concept of performativity in the case of pornography, arguing that pornography as a representation, so again, a relatively broad framing of a speech act, is something that does things. And what it does is that it constructs, usually, and in her argument, certainly at that point, it constructs women as subordinate, it constructs female desire as something that is, in a lot of ways, both assumed and unexpressed, and in that sense, both invokes and justifies violent acts. It basically invokes and justifies sexual violence or gender-based violence. And then McKinnon expands this argument to apply to sexual harassment and racism as well, saying that, again, much like forms of sexual harassment that we certainly today identify as sexual harassment, for instance, catcalling, or racism in the sense of microaggressions. They're not only words, so they do not only say stuff, but they actually impact people both by making it clear that this is something that's possible in that particular social, political, historical context, but also by directly, more or less, wounding people, so impacting them regardless of whether they agree with them, whether they want to hear them, and so on and so forth. Now, Butler took a bit of, and I want to say kind of a partial exception to the McKinnon view and that tradition of feminist writing, insofar as Butler said that it's kind of difficult to argue that speech harms in and of or by itself. And Butler becomes very attentive to the legal frameworks or relations of power that actually enable speech to become performative. So what they ask is effectively, okay, beyond legal allowances for freedom of speech of the First Amendment sort, what is it that makes it possible for speech to wound? And is it sufficient that speech is not prescribed? So is it sufficient, for instance, for pornography to be illegal in order for pornography to construct, or in order for women to be constructed as, in different ways, subordinate, including as, in a manner of speaking, being deserving of a certain kind of treatment in the context of certainly heterosexual relations. And now to add my own argument to this noteworthy roll call, what I'm in particular interested in and have worked on in the context of performativity are institutional frameworks, or what we could call platforms in the broadest sense, of possibility. So seeing institutions as something that is both constitutive of and constituted by speech acts. What is it that speech acts actually do? So this is the position from which I'm interested in the kind of speech acts that the intersection between freedom of speech and academic freedom, and in particular, their legal identity, I guess, has. So that requires us to some degree define the distinction between speech as, or speech acts as, utterance on the one hand. So to remind you, in Austin's view, illocutionary speech acts are those that act just by the mere fact of being uttered, being said. Saying I apologize constitutes an apology. Perlocutionary speech acts are those that act if certain other conditions obtain. And this brings us to the question of potential failure or success of speech act. Again, to remind you, if I claim that I am taking someone to be my marital partner, that speech act can only be a successful speech act, according to Austin's view at least, if this particular statement is uttered in a particular ceremony, in a legally defined context, and so on and so forth. And not least of all, obviously, if it's uttered in the context of a legal framework, national legal framework, that makes that kind of act possible in the first place. And this is where, in part, where my own interest comes in. But quite importantly, the distinction between successive speech is not the same, or the role of the distinction between success and failure of speech is not the same as the distinction between success and failure of speech act. It's quite conceivable that we will be able to say stuff without that stuff becoming effective, as Butler recognizes. So, for instance, in Butler's view, performativity does not, in and of itself, rest on legal allowances. It rests on the intertwinement between law, or possibility of speech, and a network of power relations that make that speech possible. So law, or speech as law, has at the same time a performative and a normative force. By performative in this particular case, I mean a relatively narrow, or I guess, a strict definition of performativity, in the sense in which obviously law can do stuff, right? Law can enact certain kinds of things. But it also has normative force, not so much in terms of stipulating moral or ethical obligations or values, because ideally we would like to think that this is something that precedes law, and that in many cases law, especially in the UK, tends only or primarily to reflect those mores or ethics that are more widely shared. But it has normative force because it reaffirms the power of legal authority as legal authority. So in that sense, law enacts stuff, or laws enact stuff, not necessarily by literally stipulating that institutions or individuals or other kind of legal persons need to do something. So they cannot, or the law cannot force people to do something, certainly not in and of by itself, but it does, in a manner of speaking, make that possible. And it also performs in the sense of perlocutionary speech acts. So in addition to what it might or might not do, so could succeed or fail, it also performs authority. It can perform control. It performs expertise. It is a form of governance, and it performs subjects, agencies, and characteristics. And this is where the distinction between speech as utterance and speech as law becomes particularly important. Butler uses an example that I want to highlight, might be a bit uncomfortable or a bit triggering for a lot of people, so I'm just going to mention it briefly. Butler discusses in their book the ruling by the US Supreme Court, which deemed that a racist demonstration outside a Black family's home that involved Ku Klux Klan insignia was not in and of itself hate speech, and certainly did not constitute violence, but was rather just a representation of violence, because it wasn't violent in and of itself. It did not harm private property. It did not harm any individual directly in terms of inflicting physical harm. And that thus it should be protected, or this is at least the ruling of the Supreme Court, that it should be protected by freedom of speech. Now, in that sense, we can clearly see that the law actually does two things. One is it enables that kind of, I think we would agree, racist harassment to happen, but it also makes it clear that it has the normative force of distinguishing between what is speech, and thus protected by freedom of speech, and what is harm, and thus potentially punishable, including by or through criminal law. So to reframe our initial questions about why legislate, who is empowered by this, and what speech does, we can talk about performative force. So what does law actually do? Subjectivation, so who becomes a subject, including a legal subject in this context. And then finally, co-constitution. So what does an institution bound by the intersection of freedom of speech and academic freedom do? And this speaks to us about the conditions of possibility in late liberalism. So what kinds of institutional enablements at the same time make institutions? So what makes the university a university? And at the same time, make institutions and make them possible. So what is the context in which a university can exist as an institution that on the one hand has the freedom to control who gets a platform, and on the other hand has, from one point onwards, in the context of the UK law since last year, has the obligation to platform certain kinds of views. If this has become a bit too recursive, I'm going to use a snippet from the freedom of speech article to perhaps clarify how this works. Now, institutions, as I'm sure will not come as a surprise to many of you, much like, for instance, gender, are not expressions of some kind of immutable essence, but rather are instituted and created through performances. And some of these performances actually take the form of small acts of repetition. For instance, giving a lecture either as a visiting speaker or as a regular employee of the institution is one such instance, and some would claim also probably one of the key iterative acts that confirm the existence of the university as a social institution. Remember Austin's perlocutionary speech acts. In order for something to constitute a declaration of getting married, the declaration itself, the statement, needs to happen in the context of a marriage ceremony. In order for something to be a university lecture, it needs to happen at a university. So this brings us to the set of questions about what is it that controlling who can get platformed in this particular case, so how a lecture can happen, does. In other words, what does mandating free speech do at universities? I'll just check how I'm doing for time. How am I doing for time? Okay, thank you very much. I think I have a few slides left. Okay, so what does mandating free speech do at universities? On the one hand, when it comes to political economy, it enables or reproduces networks of power and prestige, and obviously circulation of social capital. Quite obviously, who gets a platform and what comes with a platform, from relatively basic stuff such as money and recognition to other more complex forms of enablement, is not irrelevant. Secondly, it enables the distribution of power within universities, not only in terms of which specific position or official has the right to shape who is invited or who is given a platform, but it also distributes power between constituent units of the university. So, for instance, banning student societies from no platforming means that certain kinds of conflict are moved from open areas, so from open contestation, mediatized, literally public, towards closed chambers or closed societies. Remember that under new legislation, there's no control, or there's no constraint for student societies to platform certain speakers, but there is a constraint on whether they could ban other student societies from platforming certain speakers. So in that sense, what it's probably most likely going to do is that it's going to move these kinds of conflicts from open contestation into the private or semi-private sphere. And don't forget that, and I'm aware of the sort of controversial nature of saying this in a UK context, where I think a lot of conflicts do tend to be relatively displaced from the public area, but contestation over platforms, as much as it can be unpleasant and can certainly take rather vicious forms, I think we'd probably all agree on that, is also a form of exercise of politics. So student societies or students who do not get to experience this form of exercise of politics will in some ways be shortchanged for something that is, I would say, an important form of political socialization, which isn't to say that it should be vicious in ways that it sometimes has been. And then last, by no means least, mandating free speech at universities also strengthens the university as a potentially punitive force. So by, for instance, making sure that students cannot protest or refuse to attend certain kinds of lectures, it basically puts them in a position in which they are being taught to the degree to which they're being disciplined, right? So it reinforces what I think we could identify as kind of an almost old school Victorian sense of education as a form of explicit disciplining, as Michel Foucault has written, but also in a manner of speaking as an almost implicit punishment. So the intersection between freedom of speech and academic freedom brings this welding or morphing of objects to relatively distinct concepts, one of them freedom of speech, the other academic freedom, in a sort of a Trojan horse form, right? And this brings us back to the question of ambiguity or our own ambivalent attachment to it. If we want to keep academic freedom, and I think a lot of academics do want to keep academic freedom, the expectation is that we would need to accept, at least those of us that are bound by UK law, and that's all of us working in institutions of higher education in the UK, that we accept freedom of speech as something that is now part or embedded in the concept of academic freedom. It's almost as if we're talking about platform logics, right? So Spotify works in a very similar way, at least if you have the sort of the free version of it. This is what I've been told, which is that, you get to listen to the music you want to, but then you also have to listen to some other numbers, right? Stuff that you don't really want to listen to, but the performers have signed a contract with Spotify, and Spotify is actually profiting from playing their stuff. So in a lot of ways, the freedom that this intersection enacts is the kind of freedom that free-range chickens have, right? So you're free to move, but within a constrained space, as long as you keep producing, obviously, and there is absolutely no control, or you have no say over what happens if someone were, for instance, to introduce a fox in your free-range pen. In other words, what we're talking about is a wholesale reframing of liberalism, the meaning of freedom. You are free to do whatever you like, except, as the name of that series of events says, except Palestine, right? This is my final slide, by the way, so I'm at the end. In classical liberalism, what you're free to do is anything, or more or less anything, except what harms other people or prevents them from exercising the same kind of freedom. This is more or less embedded in the Kantian categorical imperative, in the sense in which it postulates that the way that you should act in ways that make sure that other people can, or that can be turned into universal law that can apply to everyone. In neoliberalism, you're kind of still free to do whatever you like, but with the exception of something that would limit other people's freedoms, including their freedom to harm. And examples of, for instance, failures of markets to regulate pollution, or more recently, failures of neoliberal governments to protect public health when it came to COVID-19 are, I think, a good or sort of sufficient case of this. And then finally, and this is what I think we're getting to now, is you're also in the most recent, I would say, iteration of post-liberalism. You're free to do whatever you like, but not to prevent others, not only from harming you, but also from harming others. For instance, you're not free to no platform a speaker who you think is harming others by their speech. Relatedly, criminalization, for instance, of climate protests is, in my view, the same kind of case. So you're not free to prevent someone from harming both human and non-human life. That, I think, is the last thing I had to say. I have a long set of selected references, and thank you for your attention.